The next case is 24-2486, Oliveira v. Naples. I'll give counsel a moment to get set up. Both counsel ready to proceed? All right, this is 24-2486, Oliveira v. Naples Golf and Beach Club. Counsel, again, 5 minutes is our default. Is that sufficient for rebuttal?
It is, Your Honor. Thank you.
All right, are you ready?
I am.
All right, please proceed.
May it please the court. My name is Daniel Schwartz. I have the privilege of representing Joannis Oliveira in this case, and in the other case, we're dealing with a constructive notice issue as well as an open and obvious defense issue. So with respect to the constructive notice issue, we think obviously that this case is controlled by Murphy.
Doesn't Murphy predate the statute, counsel?
It does.
Isn't that the biggest weakness there?
It does, but it still deals with a constructive notice issue. And the statute really is a codification of what happened in the common law. So it's at least persuasive.
Is it really just a pure codification or was it a limitation?
I believe it was a limitation, but I think it would still be persuasive in the context of what we're dealing here, especially given how analogous that the facts are.
Well, kind of depends on, well, it doesn't really depend on how the analogous the facts are. It depends on how well the facts fit under what the legislature intended to limit, right? Like if it's in with the, if the case is within what the legislature intended to preserve in the common law, then that'd be persuasive. If it's in the part the legislature was intending to limit, it would be the opposite of persuasive, right?
I agree, but I don't think that it changed anything that was different under the common law, because really what we're dealing with is.
You don't think the statute changed the common law at all?
Well, I'm saying with respect to the issues here, because we're dealing with zone of risk issues. That's just general negligence. That hasn't changed at all. We're dealing with foreseeability of a dangerous condition. Nothing there has changed with respect to the common law as to negligence.
All right, I'm not sure I agree with that, but let me just ask you. So I was thinking about how to define the condition here, and your argument seems to be that the dangerous condition existed because they could see these palm fronds rotting on the trees, so they knew they would fall. And that seems to me to not be knowledge that the dangerous condition existed. It would seem to be knowledge that circumstances are such that a dangerous condition could exist at some time in the future. If you see a palm frond rotting on a tree and it hasn't fallen yet, there's no dangerous condition yet. You just have knowledge that a dangerous condition may arise at some time in the future. Does that make sense to you?
It does, but I think that goes to foreseeability. And again, the knowledge that a general zone of risk is going to develop.
All right, counsel, I've got a statute.
Yes.
All right. Telling you, I'm looking at statutes. That statute says dangerous condition existed for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition. So I need some evidence, and the regularity is separate. We can get to that if you want to move on to that. But right now we're under A, so I want you to respond under A. I need evidence of the length of time that this condition existed. Palm frond is on the ground. What is the evidence of the length of time that that palm frond was on the ground?
I would say that the best evidence is that there was a storm earlier and that it would have been blown down and that they had time to perform an inspection that it would have, and it wasn't up.
All right, so that's not evidence that it was there because you don't know whether it fell during the storm, right?
Correct. It's an inference. Correct.
Yeah. So, but I mean, it's just, yeah, okay. That doesn't tell you the length of time it was there. It allows you to speculate, well, maybe it fell during the storm. Could have also fallen after, right?
It could have fallen after, but as the testimony of the employees established, there's a gap in when their inspections typically take place.
Right.
We don't actually have knowledge that the inspections did take place because there is no evidence of that.
But you've got a burden to show that the condition existed for such a length of time. So I get you what you're trying to say is, well, they should have figured this out. I've got a statute here. Is there any, if the answer is no, just we can say no and I'll move on because there's another part of the statute you can go under, right? But I'm not going to let this go until I get a straight answer. Is there any evidence of the length of time this palm frond was on the ground?
I have nothing other than what I've already expressed.
Okay. All right. All right, go ahead.
So I can keep going under Murphy unless the court has any other questions about that issue.
I do have a question as to, didn't the arborist testify that the dangerous condition exists and concludes really once the palm frond falls on the ground? It only exists when it's still attached to the tree?
I think the only problem with the way you formulated it is that when it only existed. That's not really in what he said. He said the dangerous condition existed at the time that it fell. He did not exclude that it existed beforehand.
Is it dangerous when it's still attached to the tree?
I would say yes, because it's foreseeable that it could fall and
Not could it become dangerous in the future? Is it dangerous when it's attached to the tree? Is there a current danger at the time it's attached?
not to a pedestrian who's walking around in the park.
Not this type of danger.
Right.
And she wasn't hit by the palm frond,
It
right?
did not fall on her head. She tripped on it as she was walking at her.
Okay. And so it's your position that the dangerous condition is the leaf on the ground, the palm frond on the ground?
Correct.
Okay.
Well,
Is there any authority, any cases that have, I know you said one case about palm fronds, those are falling. You have any other authority that, or other courts that have also considered that a dangerous condition?
Murphy is the only case that I'm aware of that has looked at palm fronds and how it.
I'm amazed there was a case just on palm fronds.
I was as well. It
And that was for a falling palm frond, right?
was a falling palm frond, but it relied on the testimony of the arborist. And if you look at the way it was formulated, the only way constructive notice would work is if it was based on the timing of how long it had been there and attached to the tree. Because
This is a different condition though, right? The condition of it being on the tree and potentially falling on someone is different than it being on the ground and somebody slipping on it, right? Those are both conditions, but they're different conditions, aren't they?
No, I would say it's the same thing because the condition is the palm frond of dying on the plant.
But counsel, that doesn't fall within the scope of the statute, right? The statute says, I mean, there's been a good focus for good reason on another part of the statute, but it starts with if a person slips and falls on a transitory substance. A hanging palm frond can't be a transitory substance until it's deposited on the ground, right?
Well, I
It's not
would say
transitory
it becomes a
substance.
transitory substance once it died because you know it's going to fall. It's not going to come back to life and stay on
I
the
guess
tree.
what I'm saying
It's
is
just not-
your case, we've got a statute here that's specific to slip and falls.
Correct.
And your case not just predates the statute, it was not a slip and fall case.
It was not a slip and fall case.
All right.
I guess going back to Judge Kamutz's question, is there a case that you're relying on that has held that a palm frond or any kind of vegetation on the ground is a dangerous condition under this statute?
Yeah, I would say field house. That's a
Which
case
one?
that field house. That
Okay.
was a case where there was a root.
Root?
I do believe that it also predated the statute, so I don't know if that would change the court's opinion on it, but that was certainly a case where they found it was a dangerous condition because it was an area that pedestrians regularly use. It was foreseeable that they could suffer that the same harm that they would suffer as if they were normally using the premises, and the court reversed in summary judgment on that issue.
Now, was this a root that had somehow been detached from its tree, or is it an actual still attached to
It
the tree,
was
but
still
above the
attached.
surface of the
Yeah.
ground?
That's the way.
That wasn't seen to be transitory. A root matted to the ground is not transitory.
Yeah, I don't think it technically addressed the statute at issue, but I'm using it to show that there was a natural vegetation and there was an issue for the plaintiff when they were walking.
Do you have any cases like, say, wet lawn clippings, for example? That'd be a good example. They get blown all over a parking lot. You see people later with a blower to move them away. Anything about that?
I haven't seen any case on that one way or the other.
The other thing I was interested to brief was the regularity. And you basically say it was regular because palm fronds fall at various places. And I'm not sure just for palm fronds falling generally around around the place is a specific condition as opposed to palm fronds falling in a specific location. Because a palm frond in one area may be dangerous and a palm frond in another area may not be dangerous. So it seems like the relevant condition to me that you'd have to establish the regularity of was a palm frond in this location.
Well, it was localized to the parking lot. That's where the palm fronds were. That's where the palm trees were. That's where they fell. That's where they had the policy to pick it up and move it out of the way of the pedestrians.
Okay, so
And that's the other, I apologize, go ahead.
Oh, no, so your condition is, that's helpful.
Yeah.
You want to define the area as the parking lot.
Correct.
Okay,
And not only that, evidence of a corrective action is constructive notice, even under the statute. And we know that the hotel has a policy that they have to go through and watch out and pull them out of the way so that the pedestrian doesn't get injured. And so that's another method of imposing constructive.
I don't see corrective action in the statute.
If you look at the Brady versus Carnival and the other cases that we cited, that's evidence because, I mean, it shows that they know about it and they're trying to do something about it. And that's what constructive knowledge is.
All right.
How many times do they have to do something about it for it to be with regularity?
You know, I think that's undefined, and I think that's something that needs to be determined on a case-by-case basis. I don't think you can ever just simply say you need to do something X times and have a one-size-fits-all kind of situation. So I don't think that's something that's been established. But here we know that they had a policy where they were checking or supposed to be checking every day. Whether they did that or whether they did not.
That anytime a business looked for something, say they went above and beyond, say something was a very rare occurrence, didn't happen regularly. Say it happened once every 5 years, once every 10 years. This business is just has the most responsible management ever. And they decide, even though no person on earth could say this happens regularly, I just want my resort to be the safest resort on the face of the planet. And I'm going to look, they'd be effectively be punished for doing that, right? The fact that they were looking out for things, no matter how irregular they were, would be evidence of regularity.
Well, I think you can say it's part and parcel of it. So you can consider it in addition to the fact that they had something that was regularly occurring. It's just simply another prong that shows that they knew something was happening.
Well, where's the evidence that they knew? Point me to the evidence that shows how many times the appellees, employees, agents saw palm fronds that had become detached and fallen on the parking lot.
I believe he said it happened every couple months and he had been there for about 5 years. So that would have been the
On the
frequency.
parking lot,
My understanding.
not on the ground next to the parking lot, not over here by the pool,
Right.
or by the golf course, whatever. No. Okay. How many times?
Every 3 to 4 months for the past 5 years that he had been.
Can you address the point of open and obvious? Why wasn't this open and obvious condition?
So the issue with the open and obvious is one, she has to be able to see it, and there's no evidence that she saw it. She testified she couldn't see it.
But whose responsibility is that? You know, if she's operating and behaving, exiting a car using normal, reasonable prudence, wouldn't it be fair to say that she would have seen that palm frond on the ground?
I think it's a practical question because if you look at the photo that we provided that we embedded in our brief, you can actually see that the door is open and it's still blocking most, if not all, of the palm
Also,
frond.
anything is not open and obvious when you've got a barrier. I think the presumption is there when people open doors, they look where they step. Right? I mean, so yeah, anything, if you put a barrier between your eyes and the thing, anything will be open and obvious.
Well, exactly.
Right.
And there's actually a number of cases that talk about the issue where if you can't see it, you can't find that it's open and obvious.
But that's my point. If the reason you can't see it is because there's a barrier that a reasonable person is expected to remove the barrier but look before they step out. You see what I'm saying?
Well, it was open and you can see that it's still blocked even when it is open. So that's why you have to put yourself in her position getting out of a hot truck.
I looked at the picture.
Yeah.
I didn't, with the door open, I didn't think that it was unable to be seen. I mean, with the door open, let me pull it up again. I'll look at the picture with you. I'm sure you got a copy of the picture. You put one in your brief.
I do.
Yeah, I mean, I'm looking at the picture. I'm just on page 3 of your brief. With that door open, I mean, it's not unable to be seen. I mean, there's a direct line of sight from where you would look down and put your foot getting out of the car.
So the door is at its max position open in that situation. I think, typically sometimes you're stepping out and opening it at the same time. That's a reasonable.
I don't think the door's at its max position. I think it's open the minimum amount it could be open for her to get out.
I would say we have to look at this in the light most favorable to the plaintiff on summary judgment. And when
Do I have to ignore my own eyes to look at the light most favorable to the plaintiff? I mean, I've got a picture here. It's. I mean, we do have to look at things in the light most favorable to non-moving. I don't think we have to look at things that could not possibly, by any stretch of the imagination, be accurate in favor of the movement. I mean, I'm looking at the picture. The door's not wide open.
Can I offer one more addition to what I
Yeah.
mentioned? If the court disagrees with me that she should have seen it, there has to be evidence that she appreciated the danger. And there simply is no evidence of that. And that's the Rocamande and the Knickerbocker case. And I want to talk about the
Doesn't that
Knickerbocker.
get back to the point of, is this a dangerous condition in the first place?
No, it shows whether she has to appreciate whether the condition was dangerous for her. For an open and obvious.
So it's a
offense.
subjective test?
It is a subjective test.
So
And
I saw those cases, and here's my question about them. It seemed like in some cases, the transitory foreign substance, basically the substance or the item was visible, but how trippable it was, for lack of a better word, was not apparent.
correct.
Right? And so it seems to me that would rely on there being an item that at least when you can look at, you could realize, not immediately realize is trippable. Right? Like I think there was one item that was like in an aisle that there was a piece sticking out that you wouldn't see.
That is part of it. There's also a case, which is the Knickerbocker case, where it was a doorway and there was like a threshold step.
Yeah.
And they stepped through it. And I think the plaintiff actually testified. He saw it. He said it was obvious. He used those words in his
It
testimony.
wasn't obvious I could trip over it.
No, he said that the door sill itself was obvious, that the object was obvious. And the court said that wasn't enough for summary judgment because the dangerous condition of the threshold was not.
No, fair enough. I guess what I'm saying is there are some conditions where the dangerousness might not be apparent, even if the item itself is. And then there are some conditions that the item itself would just be the dangerousness and the item, how trippable it is just obvious. Right. So doesn't that rely on kind of the item being something where you could notice it with the dangerous nature of the trippability, right? Not being obvious?
I'm not quite following the question.
Wouldn't that have to be some type of object where even if the object itself is obvious, the trippability or the dangerousness of it is not?
Well,
You can have items where the object and the trippability are just synonymous because it's just obvious that it's trippable.
well, I would again just go back to the Knickerbocker case. I mean, you would think that an obstruction in your doorway would be something that would be obvious, and the court said no, it's not. You do like most favorable to the plaintiff. It's something that needs to be resolved by a jury. So I think it depends. You know,
Sorry, Cal, what was the name of that case again?
the Knickerbocker case.
Can you just go into a little bit more? You said that the standard would be subjective if it was dangerous for that person specifically. Is that
Well,
go into that a little bit more?
and I apologize. When I say subjective, I mean taking into account all of the circumstances of the attendance situation. So again, the open and obvious defense requires you to take a holistic view of everything. That's why I brought up the issue about stepping out of the car. You're not just, you know, when we look at the photo, it's easy to say, well, yes, I can see it right here. But it doesn't take into account what she was doing in that situation where she was stepping out of a car and taking.
But the standard would be how a reasonably prudent person would behave in that situation, right?
No, it would be how Miss Oliveira or someone in Miss Oliveira's shoes at that time. Yes.
A reasonable person in her shoes. right?
Yes. Yes.
Yeah, so from her perspective, but a reasonable person from her perspective.
Agreed. Yes.
Her physical perspective, but not her actual person.
Yes.
If she's not entitled to act unreasonably.
Right.
Counsel. Counsel.
Thank you, Your Honor. May it please the court, my name is Michael Belugo from the law firm of Wicker Smith here in Orlando, and I represent the Naples Beach Hotel, which I will refer to as Naples. Yeah, I can tell from the questioning that the court is fully aware of all the facts in this case, so I'm not going to delve into too much of that. But one key fact is the affidavit of the expert witness that the plaintiff offered, the arborist, Mr. Samnick, in which he testified that the subject frond was a dangerous condition that existed when it failed. And that's at page 187 of the record. And so it's our position that the dangerous condition was the palm frond on the ground, and that there is absolutely no evidence in this record as to when that palm frond fell.
Counsel, I thought, I took your point as the affidavit and I read it in brief. I thought what he said about the parking lot was interesting. Can you talk about the regularity? Because I think defining the area is important.
Sure.
Right? I think if a palm frond regularly fell 3 inches over, you wouldn't say, well, it doesn't happen regularly. It's 3 inches to the left, right? You'd say that's the same area. And so they've defined the area as the parking lot and said that there was evidence that palm fronds regularly fell into the parking lot. Can you respond to that?
Sure. Now I'll defer to the, in looking at everything in the light most favorable to the non-moving party, in this case, the plaintiff appellant. If you look at if the parking lot is the area, the testimony still only says or only shows that this would occur every few months. The testimony is from the security officer, Mr. Daniel Kazmerzak. And he said that
That's an interesting thing because regularly, I'm not sure it denotes a specific frequency, it just promotes regularity. Like if something happened once per year, every year on the dot at the same time, you would say that's a regular occurrence, right? Regular kind of doesn't necessarily denote a specific frequency, does it? Or like a very high frequency, just that it's regular. Like if something happened every 10 years, would that not be regular?
sure, Haley's Comet is regular.
Yeah, every
Yeah.
75 years. So that's my point. You say, well, he only said it happened every few months.
And it's random. It's around the entire property. So we're not talking about a specific location. We're talking about the parking lot in general. But there is no evidence to suggest that there were palm fronds that would regularly fall at this location.
Did it then, and by this location, you mean the parking lot?
No, by this location, I mean where Miss Oliveira fell.
All right, I'm asking you to talk about the parking lot. What is your view of the testimony?
The
as to-
testimony of
as to
Mr. Cas-
Palm falling in the parking lot.
Every few months is what the testimony was from Mr. Casper. So, and again, looking in the light most favorable to the plaintiff, looking at if you're going to define the area as the parking lot as a whole, that's the testimony, is that it occurred
Every few months, not regular?
Well, it's random though. It's not something that happens on a specific,
You didn't
location.
say it was random, you said every few months. That seems like a specific interval, doesn't it?
So every 3 or 4 months they're doing a daily inspection, looking for these things, and clearing them out when the testimony is if you see it, grab it and get it out of the way. That they have a crew that comes in, I think pre-dawn, every day and inspects the parking lot, removes the palm fronds. So again, I go back to when did the dangerous condition come into existence? When the palm frond fell.
Well, that's A. I hear you on A. I'm wondering about B. Right?
And I don't think-
You don't have to show the length of time it was there if you show it occurred regularly. And I guess what I'm saying is if you got testimony saying, well, it's every few months, is that not regularly?
I would say under the facts of this case, no, that is not regular. That doesn't satisfy the regularity prong of
Why?
the statute. Because it's random. Okay, yes, you say it's every few months, but
But you're saying it's random. He didn't say random. He said every few months.
that's correct. And I'm qualifying that and saying that what he is saying is every few months is in fact a random occurrence. It does happen with
Let me follow
regularity.
up with that and then follow up with Judge Mine's question as far as the regularity. So this arborist, did the arborist testify that every few months, that was the nature of the palm tree, that they shed their fronds every 3 months, for example?
No, that was the testimony of the security guard or security person, employee of the facility, talking about how frequently palm fronds would become detached from trees on that property.
And was it attached to was there some testimony regarding why that happened? So I guess your answer to my question is, was there testimony that this was something in the nature of this plant that happened as part of the plant's natural life? You're saying there's no evidence of that.
I don't want to state unequivocally that there's no evidence of that because I'm not exactly sure.
I think what you're saying is he was speaking kind of colloquially, right? Like if he had said this happens every 3 months on the dot, you would probably agree that's regularly.
Right.
And I think what you're trying to say is what he meant by every few months was kind of every once in a while, not absolutely on the clock every few months.
Correct. It's actually a page.
Is that two different ways to read the testimony though?
I'm just going to draw your attention to page 400 and 401 of the record, which is the testimony on this issue by Mr. Kazmerzak. And again, you're right. It was sort of an informal, colloquial conversation that was going on during the deposition. That he testified that it would be months between palm fronds falling. That's the testimony.
Did he attach it to anything like, say, rain events, storm events?
He did not.
Thank you.
So going back to prong A, there's no evidence of when the palm frond fell. And as to prong B, we would argue that this was not a regular occurrence. And as an alternative conclusion, the trial court found that this palm frond was open and obvious. And the issue, I think, for this court is established by the Early versus Morrison cafeteria case. That's a Supreme Court case from 1952. I know it's an old case, but it's been reaffirmed. This issue has been reaffirmed.
Reaffirmed or not, that's, once they've overruled it, we've got to
No,
follow it.
that's true.
What was the
And
name
that-
again, counsel?
Early,
Say Early?
Early versus Morrison Cafeteria, 61 Southern Second, 477. And at page 478, the Supreme Court stated it is equally well settled that the proprietor has a right to assume that the invitee will perceive that which would be obvious to him upon ordinary use of his own senses. And so I think that's directly pertinent to this case here. Miss Oliveira, when she got out of her car, she opened her door. She had to open the door to be able to get out. And once she opened the door, she should have perceived the palm frond using her ordinary senses.
Does
And
everybody always look down when they get out of their car? Do they always like, if they stop in a parking lot? Do they always look?
I can't
right
speak for
outside?
everyone, but
I mean, wouldn't that have to, in order for us to send that, wouldn't that mean that an ordinary reasonable person looks outside their door before they step outside of a car?
I think that a reasonable, ordinary person would watch where their foot, where they're stepping when they get out of a car, where they're walking. And that's what these, the
If that was
numerous
the case,
cases.
would there not be slip and fall cases?
I'm sorry?
If that was the case, wouldn't there not be slip and fall cases?
Well,
Everybody always is expected to.
if
see
there's a
the
dangerous condition that is unknown to the plaintiff, but that again goes to, the statute that we've talked a lot about this morning, that sets forth the parameters of what you have to demonstrate for there to be liability. Yes, there absolutely would be slip and fall cases if the business owner runs afoul of the statutory provision that we've been talking about, doesn't conduct regular inspections, does not, take action when they have actual notice of something, and allows a dangerous condition to exist for a certain period of time. That's when you would have liability. So it's not that we would never have.
I think your argument
cases.
was even if A and B, were met, but you get to open and obvious, right?
I'm saying they're alternative theories.
I know, I think what you're saying is though, that you went under either.
That's correct.
All right, so that means that open and obvious kind of has to stand alone, that even if you lose under, constructive notice, you should nonetheless win under open and obvious, right?
I have to win on either.
Yeah,
If I win on either, I win.
yeah, correct. And so kind of your open and obvious assumes you lost on constructive notice.
No, I'd like to win twice.
Okay, all right, but what I'm saying is the open and obvious has to stand alone. It has to be that it can get you out of liability even when you had constructive notice, right? That's how,
That's correct. If
Okay.
the court finds that, we lose on the regularity issue, we can still win if the court
I
finds that it's open and
take
obvious.
some laundry detergent in the, in the line, in the aisle at the grocery store. If the answer is, well, everybody should always be looking where they're walking, nobody would ever be able to sue for slipping on the laundry detergent, right? Like if you're just saying she should always notice anything.
If
in front
there
of her.
is, I'm saying that when you're getting out of a car, you watch where you're putting your feet. If you're in if you're in a supermarket and there is a transitory foreign substance that has been on the floor for a certain period of time, and that period of time has been established, then the business owner can be liable under those circumstances.
All right, so I guess what I'm saying is your argument as to open and obvious relies on us finding as a matter of law that somebody getting out of a car, a reasonable person looks at the ground before they step out of the car.
That's correct.
Do we also have to find that, let's say we agree with you that a reasonable person should look where they're stepping as they get out of a vehicle? And had she done that, she would have seen the palm front. We also have to find, you have to establish that she could appreciate the danger caused by that palm.
That would be, yes, we would have to show that.
So what's your argument? Because counsel makes that argument as well, is that even if we find she should have seen it, her looking
It's not
the wrong place
right, it's
doesn't
not-
matter because it wasn't open, the danger wasn't. And he cites the case, I think it was Knickerbocker, about the threshold.
Correct. In order for my client to prevail, we would have to show that not only was the palm frond an open and obvious condition, but that its dangerousness.
It's trippability.
It's trippability. I've not heard that word before this morning, but yes, it's the danger that it may cause someone to slip and fall would also have to be perceived. That is correct. I agree with that. And I think that this, on this record, that shows that, that's what the trial court concluded. And I think that the trial court was right in reaching that conclusion.
And what are you relying on for that aspect of it, in terms of in the light most favorable, what the evidence shows?
I'm relying entirely on that picture.
Does it matter whether the palm frond is wet or dry?
I believe the testimony from Ms. Oliveira was that it was wet.
Does it matter whether the parking lot was wet or dry?
I don't think so, because the parking lot itself is not a dangerous condition. It's the palm frond itself that's a dangerous condition.
But she said it was wet, because she knew, because she slipped on it. She didn't say she could tell it was wet before she slipped on it, right?
That is correct.
So the wet nature, there's no testimony that the wet nature of the palm frond was apparent.
Well, she was aware that it had rained. She did testify to that it had rained earlier during the day. So I think, yeah, she was aware of the wetness of it.
Does it matter that the parking lot appears to be asphalt?
I don't believe so.
So the open and obvious nature of the danger would be the same for wet asphalt as it would, say, wet terrazzo floor.
I mean, I'm not aware of any part of the record that would speak to that. So
Visually, do you think a reasonable person looking at that parking lot might think that it has a high coefficient of friction and not really slippery?
Well, I'm not sure that that's relevant though, because we're talking about the palm frond, not the surface of the parking lot. At least there's no testimony, there's no expert testimony that talks about coefficient of friction and raises issues like that. The testimony is simply the palm frond was on the ground. She should have seen it when she opened the door to the car. I think that the picture does show that she certainly had the ability to see it. And I also want to point out that she never testified in her deposition that she couldn't see it. She said,
Did she testify as to whether her foot moved on the palm frond and the palm frond remained in the same spot on the parking lot, or whether her foot and the palm frond also moved along the surface of the parking lot? And follow-up question to that was, if so, does it matter?
I believe it was the latter, and I don't think it does matter under these circumstances. Her testimony is, quote, "And as soon as I opened the door, I didn't see any, I can't see. I opened the door, I walked out, and I slipped on wet palm trees." That's at page 113 of the record. And then on the following page, she stated, quote, "I was normal as soon as I got out of the car, just opened the door, just come off the car, so I guess holding the door." That's at page 114 of the record. There's no other reference in her deposition of her view being blocked, obstructed, or that she could not see. That appears nowhere in her deposition. So I think that just looking at the picture, it demonstrates that when she opens the door, she can see the palm frond. And she, I think, as the trial court ruled, and I would ask that this court affirm, that she should have appreciated, using her ordinary senses, she should have appreciated the danger that palm frond presented, and that she should have avoided it. And unless the panel has any further questions, we'll rely on our brief, and we would ask that you affirm. Thank you.
Counsel?
So I'd like to pick up right where he left off, and that's with the discussion about stepping out of the car. And I think an ordinary reasonable person has a right to expect that when you're stepping out into a parking lot, as the court said, you're stepping out onto asphalt. You're not necessarily expecting to step out onto a large wet palm frond. It's just not something you normally see. So that's why there's a question of fact on that issue. With respect to the open and obvious defense, that only applies to the failure to warn claim. So even if we prove constructive notice, and he prevails on the open and obvious defense, we still get to go down on the failure to maintain claim. I just want to make that clear.
And so you've got a couple minutes left, this idea of regularity.
Sure.
And the testimony of the maintenance worker as to regularity. Because every few months, or forget the exact phrasing. Give me your best minute 52 seconds that shows regularity?
I mean, 3 to 4 months for 5 years.
Is a reasonable reading of that testimony was that he was giving kind of a fixed time frame that it happens?
I mean, his testimony is his testimony. That's all I can say. If he's saying it happens every 3 to 4 months for the 5 years, that's 4 times a year for 5 years. That's 20 times before this happened. I would say that meets the threshold of regularity, or at least enough to go to a jury because there's a competing inference of fact on. Unless the courts have any other questions, I'm going the rest of my papers. I'm going to ask that the court reverse.
Thanks to both counsel for your arguments. All right, we're going to take a brief recess.